Hello, this is our second narrated PowerPoint on Study Unit 1, Introduction to the Law of Things and the Law of Property. In this narration, we will specifically focus on the function, place, and scope of property law and the law of things.
Now, as with any other law or area of law, the law needs to have a function. We must be able to ask ourselves, what is the function of having this area of law? What does it help with? What does it assist with? And when it comes to property law, it needs to be noted that property law has a dual function, namely a formal function and a social function. The formal function of property law must be viewed and understood with its social function in mind in order to ensure the effective application of the legal norms at work in the legal system. Now, in terms of the formal function, property law is aimed at the following. So it is aimed at protecting and regulating the acquisition, enjoyment, and disposal of property. This entails guaranteeing and protecting individual rights. It is also burdened with harmonizing individual interests and rights with regard to the same property. For instance, when one person has ownership over property and another has a use right in the same property, these competing rights requires harmonization. This harmonization function also extends to the harmonization of individual interests and rights with regard to different property. A nice example of this type of situation that necessitates harmony is a neighboring owner who does things on her property that is interfering with a neighboring owner's use and enjoyment of her property. So the situation where you have neighboring owners or two pieces of land with houses on adjacent to each other that belongs to two different owners, where these two different owners want to use their property, their land, their house. They want to use and enjoy it in their own unique way. But then the law of property must make sure that each of them use their property in a way that does not interfere with the other one's rights to enjoy and use their property. So, as is evident from this explanation of the formal function of property, it must be clear that the formal function of property regulates the protection and harmonization of rights in and over property. Now let's turn to the social function of property, or rather the law of property. The social function of property law is based on the idea that the acquisition and maintenance of wealth, which is made possible by the formal function of property law, does not take place in a vacuum. It takes place where people live in close proximity to each other with conflicting interests. And these interests can be legally recognized or unrecognized. Now, this social function concerns the idea that property law includes responsibilities and that it also regulates these responsibilities. So property law includes responsibilities and it also regulates these responsibilities. In other words, the focus is on the responsibilities of legal subjects with regard, or rather with rights over legal objects to other legal subjects in society. So the focus is on the responsibilities of legal subjects with rights over legal objects to other legal subjects in society. Therefore, the social function entails the management and regulation of competing interests of persons who are acquire and enjoy property at the expense of others. We see this taking place in public law regulation of property. So, for example, there is legislation, various different types of legislation that regulates how one may use your property. Okay? This regulation would normally be in the interest of society, or rather is required to be in the interest of society. An easy example would be regulations that prohibits a person from driving a high speed in specific areas. That piece of legislation inhibits an owner's right or a motor vehicle owner's right to use and enjoy the car or the motor vehicle as he or she pleases by placing that speed limit on the owner. So this is a nice example then of public law regulation of property in the interest of the broader public. We also see then the social function playing out when it comes to the Constitution and property law. For instance, there are limitations placed on property law by way of constitutional provisions, such as Section 25 and Section 26. These provisions are evidence of the social function of property that is at work. Why? Because Section 25 in itself as a constitutional provision provides for this, or provides the state power, or gives the state the power to regulate how owners use their property, or how people with rights in property may exercise those rights. And that way, then limiting how people with rights in property may exercise their rights. In the same way, we see Section 26, the housing clause, also placing certain limitations on how property right holders may exercise their rights. And this limitation is in favor or to allow for housing rights to also realize. So where does property law fit into the framework of the law? To answer this question, we need to first locate property law within the area of law called private law. Now, property law forms part of patrimonial law. As you see on the image, patrimonial law is a sphere of law which includes the law of succession, the law of obligations, and also the law of property. The reason why these areas are regarded as forming part of patrimonial law is because they deal with assets in a person's or juristic person's estate. For our purposes, property law forms part of patrimonial law since it deals with the various assets or belongings that forms part of a person's estate and over which a person can have rights. Now, when considering the place of property law and also taking into consideration public law and the Constitution, the following becomes evident. So there is a normal or ordinary distinction that is upheld between private law and public law. This distinction can be described as follows. Public law regulates the relationship between private individuals and the state, while private law regulates the relationship between private individuals. But although property law is traditionally categorized under the private law part of the law, it unavoidably forms part of public law. This means that property law cannot be divorced from public law. The traditional distinction between public and private law as just explained, cannot be maintained when it comes to property law. And this is also neatly illustrated in the image that's provided on the slide. Now, the reason why it is not possible to divorce property law from private law and just put it in a private law box is because the state plays an active role in aspects of private life, specifically aspects that deals with property. Now, one example of where public actors features in private law relations is where a purchaser of land or a house must transfer or acquire ownership over land or the house. Now, in that process, the state has an important role to play, and this role is delineated in the Deeds Registries Act. Another example of where the state plays an important role in private life, specifically dealing with property, is where constitutional provisions finds application. Specifically, if we look at the right of equality, if we look at Section 25 of the Constitution, that's the property clause, as well as Section 26, that's the housing clause. Legal norms in public law informs legal relations between private parties and their property because of the Constitution. So when considering the scope of property law, it must be appreciated that property law regulates objects that qualify as property. So the law of property regulates the relationship between legal subjects and legal objects called property. Property concerns the assets that forms part of a person's estate. The property regulated by the law of property includes a wide range of different legal objects, namely corporeal property, meaning tangible objects, incorporeal property, meaning intangible objects, informal or formal rights and interests, public law relationships of patrimonial nature, as well as constitutional property. So understanding what would qualify as property tells you what is then regulated and what falls within the scope of property law. However, as indicated earlier on in this narration, the law of property is a broader field that includes the law of things. So the law of things, specifically referring to the name of this course, is a genus or category of the law of property. And it only regulates the relationship between legal subjects and things specifically. So not property, but specifically things. Now, things have very specific characteristics that we will be looking at in the second segment of Study Unit 1 narrations. However, as per introduction, only corporeal independent legal objects that has use and value and that are situated outside of the human body, in other words, that are of an impersonal nature and that are susceptible to human control, would qualify as a thing. So would qualify as the subcategory of property, namely a thing. The law of things is therefore a limited genus of the broader property law. The law of things forms part of the received common law. Now, although this course is called the law of things, we will look at the law of property broadly to the extent it is necessary, since it is unacceptable to only teach the common law of things for constitutional, political, economical, and systemic reasons that will become apparent as we grapple with the content of this module.